A civil society group, the Advocacy for Advancement of Peace and Harmony in Africa initiative, has called on the judiciary to carefully look into the merits of the Nasarawa governorship election dispute, which it says the State Election Petition Tribunal failed to observe before delivering its recent ruling. Leaders of the group who addressed journalists in Lagos said the tribunal, which nullified the election of Governor Abdullahi Sule, did not do much to explore merits of the case before delivering its judgment. The group said the judiciary remains the last hope of the common man and should always uphold that belief. Joining us now to discuss issues arising from the gubernatorial election petition tribunal that sacked Governor Sule of Nasarawa State and had to reduce the role of the judiciary in determining electoral mandate is Barrister John Mathew, a senior advocate of Nigeria. Great to have you on Newsday.
Thank you for having me, but let me quickly correct this impression. I'm not a senior advocate. I'm a very senior lawyer.
Very good. Thank you for that correction. Now, Barrister Mathew, from a legal point of view, what major cues led to the nullification of Abdullahi Sule as governor of Nasarawa State?
Well, very simple. The facts that the petitioners took to the tribunal were simply incontrovertible. The case of the petitioner was plain for everybody to see. The allegations before the Election Petition Tribunal is that polling unit results were available where elections took place all over the state, but the computation of those results were not reflected in the final collation. And so the petitioners invited the tribunal to recompute. And whereas the petitioner tabled all the polling unit results of the areas in contention, the respondents, particularly INEC, which conducted the election and which had the opportunity to come and explain how it came about its computation, did not avail itself of that opportunity. It filed a defense but abandoned it, did not call one single witness. So the tribunal was left with only the results as presented by the petitioners, which were duly certified by INEC, and the tribunal had no difficulty in recomputing the figures and arriving at a just determination. So, the merits of this case was thoroughly considered. It is rather the respondent that would wish the tribunal were engaged in technicalities, which was the entire gamut of their defense.
Thank you very much for that insightful breakdown of what took place. Now, Barrister Mathew, it seems like a pretty straightforward case and a pretty obvious judgment given the breakdown that you've given us. Now, what foundation do advocacy groups and, of course, the sitting governor himself, what foundation do they have, what grounds do they have for appeal and for causing the stir in the polity that has currently been stirred up because they feel that this is unjust?
Now, the entire gamut of their defense, like I said, is based on technicalities. They have abandoned the claims before the tribunal, which is, here are the facts and the figures. Do they add up to the declaration that was made? If they didn't add up, was the tribunal justified in making the correct additions? Now, INEC, in declaring Governor Sule on the 20th day of March, when the results were declared, gave Governor Sule a margin of 64,193 votes as the margin with which he won the elections. Now, you recall that the tribunal, in arriving at its judgment on the 2nd of October, even the dissenting judgment, which Governor Sule is relying on as a basis of his appeal, came down with a margin of 3,799 votes. So, where did INEC get the over 60,000 votes they padded for Governor Sule? This remains a mystery. And so, somebody did this padding. That was obviously INEC. They had the opportunity to have called evidence at the tribunal to explain how the extra 60 votes they added to the governor came about. They didn't avail themselves of that opportunity. So it's surprising that anybody will be crying foul that substantial justice was not done. We are also curiously waiting for the type of grounds of appeal they wish to come up with. But I can assure you that it cannot be on the substance of the case. It can only be on technicalities. And I know that our superior courts have moved away from technicalities in doing substantial justice, and I expect the same to happen in respect of this case.
Very good, Barrister Mathew. Now, we are seeing a rise in scenarios where the judiciary is determining electoral mandates. Is this indicative of flaws in our electoral system at this rate?
I think more than anything else, there has been some improvement that were introduced in the electoral process. But most of the introduction forgot the human element. If you notice the trend of petitions that were brought this time around, they were not questioning the nature of the conduct of the elections in the field. Rather, it's the aftermath, after elections, the computation and the determination of who won. So, those who are saddled with the responsibility of making the exact entries into the exact forms, particularly as in this case, are the ones who are complicit. Where you have an ad hoc staff of INEC saddled with the responsibility and also with the guidelines of making the proper entries and making the returns, checking his responsibility, such as was done in this case, it means that in spite of our innovations, there has to be a searchlight beamed on INEC with respect to the way they carry out their responsibilities. Because if, for example, the mistakes that were done in computation were just about 1,000 or a few hundreds, one can understand that to be human error. But the situation where over 60,000 were added to a party just in 2 electoral wards, it calls to mind that there must have been some unholy alliance in arriving at this kind of brazen subversion of the people's will. And I think this is exactly what this tribunal has done by taking a critical look at the figures that were available to it and coming to a determination that these were the proper results that ought to have been declared. And if I may just add at this point, I think it is important that litigants should be wary of casting aspersions at their lordships, like is being done by Governor Sule, particularly in Nasarawa State. Just yesterday, at a public forum on national television, the governor came up with explanation why he lost at the tribunal, that 2 out of the 3 judges were Christians and 1 was a Muslim. That was why the 2 Christian judges gave judgment for the candidate of the PDP, and the 1 Muslim judge gave judgment for him, who is a Muslim. I think this is highly uncalled for. I'm saying this because their lordships cannot defend themselves. In 2019, the tribunal that decided the elections in Nasarawa State had a similar composition. They unanimously gave him judgment. Against the same candidate who has now won, he saw no reason to raise complaints then. People who are in leadership position must be careful about the unguarded statements they make, which is capable of inciting a very peaceful state like Nasarawa State, where you have in every family Christians and Muslims coexisting peacefully.
So many intricacies and nuances to what's playing out currently in Nasarawa State, but I want to take us back to holding INEC accountable. And, earlier you did make reference to legal technicalities. How does INEC take accountability in a climb where we've seen that, indeed, legal technicalities can get them off the hook relatively easily? And how do we then get legitimacy to those who have won their petitions through the legal process? Because many then feel that these are legal victories, but not necessarily electoral mandates.
Well, the situation, why I insist that only legal technicalities can be taken up at the appellate proceeding is because of the indications of what took place at the lower tribunal. Instead of INEC, whose conduct was called in question in this petition, to come up with explanation, particularly call evidence as to the respective officers who did the computation to come forward and explain where they got the extra figures. But what they resorted to doing is to say, these witnesses you have brought forward, we don't recognize them as our witnesses, or you subpoena them from our organization without following the proper channel. These are the kind of technicalities they have come forward with. Questioning witnesses whom they allowed to participate as agents, who signed duly produced results before them, only at the point of giving evidence with respect to what was produced. That was when they chose to begin to question the kind of witnesses that were brought forward. But they had opportunity to have brought their own witnesses. They had opportunities to have brought different results that suggest and backs the figures they came up with. They didn't take those opportunities. The courts must, of necessity, seize the opportunity to do substantial justice where the figures and where the evidence is overwhelming, like was done in this case. And I think that is the way forward if we must improve our electoral process.
Indeed, on that note, Barrister John Mathew, legal practitioner, would like to thank you for your perspective on Nasarawa. It's good to have you with us.